everybody, in this lecture, we will look at the definition and legal nature of partnerships, the 3 essentialia necessary for a partnership contract or agreement to come into existence, and the Naturalia or the consequences that flow from such a partnership agreement or contract. We will define a partnership and investigate its legal nature. And then we will focus on the basic requirements of a partnership agreement, and we will in detail explain what constitutes a valid contract, and then look at the 3 essentialia of a partnership pertaining to the contributions that must be made unconditionally, the objective of our partnership to be making profit, and then the carrying out of a business for the joint benefit of all the partners. We will also explore the 5 naturalia or consequences that flow from a partnership agreement. A partnership can be defined as a legal relationship which arises contractually between 2 or more persons. And these partners or persons need to agree to contribute to a common business. And the object of this business is to make a profit that will be divided between the various partners. A partnership is not a separate legal entity with separate legal personality, but in some limited instances, the law does treat it as a separate entity. For example, when one wants to sue, it can be done in the name of the partnership and does not have to be in the names of the individual partners. Creditors can claim against the partnership, but also against the individual partners. And for the purposes of sequestration, a partnership can be treated as separate from its members. A partnership is essentially a type of agreement or contract, and therefore it must comply with the general requirements for a valid contract. Firstly, parties must have the capacity to enter into a contract. They must have the intention to not create anything else but a partnership agreement. They must reach an agreement, and then this agreement or contract must be lawful, and it must be possible to render performance according to this agreement or contract. In terms of a partnership, no registration is necessary, and therefore no formalities. A partnership agreement can be either a written agreement, an oral agreement, or a tacit agreement. Then, the essentialia or basic requirements or key elements necessary for a partnership agreement to come into existence after it can be deemed as a valid contract is there must be a contribution, and this contribution must be unconditional. The object of the partnership must be to make a profit, and the partnership must be a business for the joint benefit of the parties. So what does all of this mean? Firstly, the key element to a partnership is that the partners must make a contribution, and this contribution must be an unconditional contribution. That means that a contribution can include very many things, from capital, services, knowledge, skills. It can be corporeal or incorporeal, or a combination thereof. But a contribution must have a commercial value, and this contribution with a commercial value must be made unconditional, which means it must be subjected to the risk of the partnership business. A person who makes a contribution to a partnership on a condition that it must be repaid irrespective of the success of this enterprise or a business is not a partner. This kind of person is a creditor. When you make a contribution that is unconditional, you give capital, services, knowledge, skills, corporeal or incorporeal things, without expecting to be repaid. The second essentialia or key element for a partnership is that the object or the goal of the partnership must be to make a profit and then to share in this profit. A profit refers to the net profit. And the net profit is, of course, the amount by which the gross income exceeds the expenses and losses. The partners can agree on how this profit should be divided, but no one can be excluded from the division. So you cannot say, no, I'm not interested in receiving a share of the profit. If that is the case, it is not a partnership. If the objective or the goal of the partnership is something else, like for example to support a particular cause, a sport cause or a cultural cause, then it cannot be a partnership, because the object of a partnership is to make profit and to share in this profit. If the purpose is charitable, it can also not be a partnership, because the aim is to make a profit that is distributed amongst the partners. The third essentialia has to do with continuing a business or carrying on a business for the joint benefit of the parties. Now, what constitutes a business? It is anything that occupies time, anything that you need to spend labor on, or that requires your attention. And what is this idea of joint benefit of the parties? What does that tell us about a partnership? Well, it tells us that it must be for the common interest of the parties. So that means that the intention of each partner should be to derive a benefit or a profit from it. It also means that the partners share in the profit and also in the losses. In the previous slide, we looked at the essentialia or basic minimum requirements necessary for a partnership to come into existence. Now, it's important to note that one cannot contract out of the three essentialia. So, in your partnership agreement, you cannot decide to not have one of the essentialia apply to your partnership. But with Naturalia, it is different. Naturalia are, of course, the natural consequences that flow from a valid contract. And you don't even have to agree to or on these consequences. They come into existence automatically through the operation of law. And in terms of Naturalia, partners can agree to not have some of these consequences apply to your specific partnership agreement. So the first natural consequence or naturalia that flows from a valid contract is the principle of agency or mutual mandate, according to which partners in a partnership have the authority to perform juristic acts in the name of the partnership. So it means that individually, without the collaboration of the other partners, each partner has the capacity to perform any legal act concerning the administration of the partnership. And there's a presumption here. So unless a third party is aware that a particular partner does not have the capacity to perform, The partnership will be bound by a contract concluded between the third party and this partner that does not have the capacity to perform. Why? Because there is a presumption that every partner, individually and without the collaboration of the other partners, has the capacity to perform any legal act pertaining to the administration of the partnership. The second naturalia has to do with how profits are shared or divided in a partnership. Partners may, of course, freely arrange or agree to the proportion in which profits will be shared. But in the absence of any provision or any agreement, the net profit is divided in the same ratio as the partners' respective contributions. So what does that mean? If you contributed 60%, your share in the profits will be 60%. And if it is impossible to value the respective contributions, then the profit will be divided equally amongst all the partners. So either you have to agree on how you will be dividing the profits, or it will be determined by looking at the respective contributions of each partner. And if that is also not possible to do, then profits will be shared equally. Then the third naturalia has to do with the obligation of the partners to share also, not in the profits, but also in the loss, and how these net losses will be divided. Well, there's an obligation on all the partners to share in the net losses, unless you have specifically agreed to be excluded from shouldering the losses. So the general rule is that all partners share not only in the profits, but also in the losses, unless specifically excluded from the obligation to share in the net loss by means of an agreement. But at least one partner will have to carry the losses in a partnership. Not all partners can agree to be excluded from shouldering the losses. So losses, in the absence of an agreement or a provision, are shared in the same proportion as the net profits. So if you have contributed, of course we are talking about a situation where there is no agreement. If you have contributed 60% of the contributions, then you will receive 60% of the net profits, but you will also have to shoulder 60% of the net losses. Sometimes this is an unfair situation because your share in the profits is not always calculated based on your respective contributions to the partnerships. So sometimes you only contribute 20% to the partnership, but according to the agreement, you share 60% of the profits. And that means then that you will also have to shoulder 60% of the losses. The fourth naturalia has to do with how assets will be divided upon dissolution. So when the partnership comes to an end, then assets will be either divided upon agreement, or if there's no agreement, in the same ratio as the profits. How? So normally if there's no agreement, a pro rata division of the assets is made upon this end of the partnership agreement or upon dissolution in proportion to the partners' respective contributions. Then lastly, how does co-ownership work in a partnership? And we have said this before, that partners have their own shares, so the share that you contribute, but then all the partners are joint co-owners of the partnership. So the partners are, in other words, co-owners, and they jointly hold the assets in undivided shares. Partners are, in other words, joint co-owners of the partnership with their individual shares in the partnership. In this lecture, we defined a partnership and investigated its legal nature. We said that a partnership does not constitute a separate legal entity, but that there are exceptions to this general rule. We focused on the basic requirements of a partnership agreement by firstly looking at what constitutes a valid contract, namely capacity to enter into a contract. There must be an agreement. The contract itself must be lawful, and it must be possible to provide the performance that you have agreed to or that you have contracted to. We also said that no formal requirements need to be complied with. Then we focused on the three key elements or essentialia of a partnership agreement. We looked at the meaning of a contribution and what it means when we say that a contribution must be made unconditional. We also reiterated that the object or goal of a partnership must be to make profit, and that it is impossible to be a partnership while being excluded from making a profit. Making a profit also includes the hope or expectation to make a profit. But if the goal of a partnership is anything but making a profit, then it cannot be a partnership. Thirdly, we said that a partnership business must be carried out for the joint benefit of all the partners. So it means that it must be in the common interest of all the parties. So each partner must share the intention to derive a benefit or a profit, in this case, from a partnership. Then we looked at the natural consequences that flow from a valid partnership agreement or contract. Those consequences that come into existence by operation of law, so automatically. Firstly, we said that each individual partner, without the collaboration of the other partners, has the capacity to perform any legal act concerning the administration of the partnership. Then we also looked at how profits are divided. And if it is not agreed upon, it will be divided proportionally according to the contributions made. We also looked at the obligation of the partners to share in the net losses and how these losses will be divided. And once again, we said that partners can agree to be excluded from sharing in the loss, but that at least one partner must carry the losses. And if there is no agreement, then the sharing of the losses will be calculated according to the sharing of the profits. How will assets be divided? We said again, assets will be divided according to the division of the profits. Then lastly, how does ownership in a partnership work? And we said that the partners hold the assets as co-owners. In other words, they jointly hold the assets in undivided shares. So, partners have their individual shares, but they own the partnership together as co-owners.